I have two motions before the court, one concerning child support and one concerning parenting time. The file's a little confusing. It appears there was a hearing in November on November 4th and an order issued on November 5th. There was also a child support order that was entered in August of 2024. So, Ms. Robrand, you say that the parties came to an agreement on parenting time, but that was in August of 2023. So that's been over a year.
That is correct, Your Honor. Their previous counsel, they entered a stipulated order on the 8th of December in 2023, and that is the parenting time schedule that the parties have been working from.
Right, but that gives him 0 overnights.
That is correct.
And the reason for that was because he had a roommate of some kind?
There were a variety of roommates in the home that he is still living in that were raising concerns at the time.
Okay.
And the parties agreed to have 0 overnights.
Understood. His motion says that he no longer has any roommates. Is that true, Mr. McNabb?
Yes, the family that was living in the basement did move out. I do rent a house.
But is that separate from where you live?
No, I live there.
Yep. Okay.
All the roommates are done. They're out of the basement. They were staying there while their house was getting built. Okay. And that lasted a little longer than anticipated. So I agreed to abolish the overnights until they moved out.
Ms. Robrand, under number 6 in your further response, it says that even if there are circumstances that have changed in the defendant's life, that's not a proper basis to request a modification to parenting time. Normally, you might be correct, but if the situation in his life was what caused the parenting time to be deleted, and that now has been eliminated, then that is a proper circumstance to then review parenting time.
Okay, there's a couple things here, Your Honor. He's still living with one of the gentlemen that were raising concerns at the time that the current order was in place. He's still living.
Is that true, sir?
Yes, Roger.
Okay, in that case, there is no change of circumstance. I can't review parenting time. If the circumstance that
I've always tried to spot from him, even years before it happened, and he's never there on the weekend.
Look, you guys entered the order because of concerns. If those concerns still exist, then there is no change of circumstance to review the order. Your motion kind of indicated that all the roommates are gone. So I thought we might have had a change of circumstance, but if the roommate's still there, that was a cause for concern. We don't have a change of circumstance to review this.
Okay. All right.
Sorry. That's why I was trying to get to the nuts and bolts of this, because
it's there for years, and I've just always been on the.
I read the case. I wasn't sure exactly what was going on because, like I said, the file's a little convoluted. That's why I had some questions, but it did appear that the order was entered into because of concerns of some people you lived with. And now I'm being told your motion indicated that those people are gone. Now you're saying that no, and they're saying that no, the guy that they had concerns of is still living there. Therefore, the condition that caused the parenting time order to be entered as it was still exists, and I can't change it. You guys signed it. You guys agreed to it. Now if that change happens and he's no longer of concern, then I can look at parenting time, but the concern's still there. Whatever it was when you guys signed this, you guys signed it. You guys did it. So obviously there were concerns that everybody had, or at least we're willing to oblige.
Okay, so, I apologize. I assume
no, that's okay. I mean, normally what I would tell you is if you have limited parenting time, the court will look at it every once in a while. Every 6 months to a year, we'll kind of revisit it because it's the child's right to parenting time with the parent, not necessarily the parent's time. I mean, not necessarily the parent's right. It's the child's right to know both parents. But if there are conditions, it's got to be done safely. And if there are concerns and those concerns still exist, I'm not touching what you guys agreed to. As to the child support, I'm not sure. Ms. Robrand, it looks like it was based on $79,000 a year.
I did not enter that order. That is something that Attorney Swears did at the time. And based on the numbers from the friend of the court. So the friend of the court did the review, and then Attorney Swears went in and did an amendment because Mr. McNabb was having trouble keeping the children on his health insurance. So we had to take another look at it.
Yeah, I saw that issue. My question was, I was trying to figure out what it was based on. In the file, it says 79,000. He's saying that he only earned 69,000.
We have no evidence.
I know I don't have evidence of that either. That's why I was going to see what I could do about that portion, because we do want to get that right. Sir, the income withholding orders are issued by the front of the court in accordance with the court order. So no attorney issues those. Those are issued by law, and they are never put in a court file because they contain information that you don't want made public. Court files are public documents. Anybody in the public can come in and look at them. So there are certain things that are constrained from the court file itself that only the front of the court will have because of personal information contained therein. Sir, if you could, I believe you have my contact information through my clerk. And what I will do is, ma'am, if it is significantly different, if it was based on 79,000 and his income was 69, I may send it to the front of the court for obvious reasons, because then we have his income wrong by a very high percentage. So that would be a change of circumstance that was not considered at the time that this was entered. And I realize it was only entered in November, or I mean, no, August. So, you know, a change of circumstance is a change of circumstance every 3 years, or a change of income. And if we've got the income wrong, that's a change. And I want to get it right. But the orthodontia is a whole different issue. That's something over and above. And that's also in the court order under the percentage of healthcare costs. That was obviously somebody did a hearing or somebody agreed to what because the front of the court will review that, find out how much it is, and then, yeah, it will automatically be taken off. They don't put the final number on it. They just add it until it's to be taken off, and then they remove it. Okay. Yeah. So I don't get, I think probably in the 18 years I've done this job, I've seen 3 income withholding orders. So the court doesn't ever get to see them. So because of the information that's on them. So, because what the court sees is going to probably go into the court file. So I don't want to do that to you. But if you could send me a copy of your most recent pay stub and your last year's pay stub. I'll need his, Miss. I don't need yours, Miss Lutz. I need Mr. McNabb. I need yours, because if it is that change, I am going to send it. So I'll reserve on that issue, pending proof that we have a change of income. Okay.
Yep.
Alrighty. So email that to my clerk, and Ms. Robrand, I will email you a redacted copy. Or, and sorry, you can redact anything appropriate on it, like social security numbers or addresses you don't want anybody to know. You can also redact it. I just need year-to-date total and the pay date, not the check issue date, the date that the pay goes through. Okay. All right. All right. Any other questions?
Your Honor, there was one other thing. There is, defendant does owe plaintiff $350 from an outstanding order. I don't know if the court would be willing to address that today. That wasn't a relief paragraph.
Right. I didn't see that as a relief paragraph. I was going to say, what is that from? That's from the show cause last November?
That is correct. He still hasn't.
Did Judge West put a time limit on that?
It was, yeah, 2 months.
Okay. If the 2 months have elapsed, Mr. McNabb, get that paid. Otherwise, then it's another show cause, and that's going to cause more costs in hearings. So, all righty.
Trying to get the money. I guess while we're here, they added on an extra $375 a month to my child support for out-of-pocket dental expense.
Yeah, I just brought that. I just explained that to you. That's orthodontia. They put it on there, and they'll automatically take it off once it's paid.
Okay.
Once it's done.
Right.
Yeah, that was that explanation earlier. Sorry, I jumped ahead. There's somebody like 350s and 370s in here that are mentioned. I'm like, I got confused. Anyway, I just got your response yesterday afternoon, Miss Robrand.
Oh, my apologies, Your Honor.
No, that's not your fault. That's I was on vacation till Wednesday. So
well, I hope you had a wonderful time. Welcome back.
Yeah, my wife did the Princess 5K, 10K, and half marathon.
That doesn't sound like a vacation.
Was for me. I slept in. I did the 5K, and it was 39 degrees in Florida.
Oh, wow. Okay.
You have to jump in the corrals at between 3 and 3:30. It was 39 degrees. The race starts at 5:30 to 6 o'clock, depending upon what corral you're in. And it got up to a whole whopping 41 degrees before the 5K was over.
Oh, wow. That's cool for Florida.
So, in any event, I got a nice medal out of it. So, you know.
Well, congratulations.
Yeah, my wife got 4 because you get a medal for each race. And if you do all 3 races, you get a 4th medal called the dopey. For obvious reasons. All right.
Well, thank you very much.
Take care. It was nice meeting you. Mr. McNabb, get that to us as soon as possible, okay?
Yep. Sounds
Take
good.
care,
Bye.
sir. All righty. Bye.
Bye.